All rise. The Court of Appeal in the 5th District of the State of Florida is now in session. The Honorable Jamie R. Grosshans, Judge presiding. All persons having business before this court drawing near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this Honorable Court. Please be seated.
Can you close the blinds behind you?
Good morning. My name is Jamie Grosshans. I've already been introduced to you today. Welcome to today's session of the 5th District Court of Appeal. I'll introduce the other judges on the panel today. To my right is Judge Jay Cohen, and he is originally from Orange County, sitting on the court. We also have today an associate judge who's a circuit judge in the Jacksonville area, Eric Roberson. I'm going to ask you all, if you wouldn't mind, please turn your cell phones off or to silent so that we don't have any interruptions with the argument today or with the judges asking the questions. Now, each side today will get 20 minutes. I will go ahead and reserve 5 minutes for the rebuttal. If you want a different amount of time, just let me know when you come up to the podium, and we will be able to accommodate that. Thank you so much. We will begin with our first case of the day, which is Violet Love-Ray versus the State of Florida.
Good morning, Your Honors. May it please the Court. Paul Regani from Orrick, Harrington, and Sutcliffe for Appellant Violet Ray. I'm happy with the default 5 minutes for rebuttal. Thank you. So we've detailed in our brief all of the ways that Violet received ineffective assistance of counsel at trial. I'd like to focus on this argument on one overarching issue that in particular underlies claims 1, 2, 4, and 5 set forth in the brief. And that issue is that trial counsel provided ineffective assistance by failing to adequately contest the state's medical theory for what happened to Faith Ray. The state's burden at trial was to prove beyond a reasonable doubt that Violet Ray beat her 2-year-old daughter to death. And it's a burden that the state sought to carry almost exclusively through the testimony of the medical examiner.
The issue with us is not to retry the case, but to make a determination as to the trial judge's findings in terms of whether there was ineffective assistance of counsel.
Absolutely, Your Honor.
That's really what the focus is for our review today. So we don't go back and retry the case.
And we're not asking, Your Honor, to go back and retry the case, but in illustrating how trial counsel's assistance was ineffective, I think it's just helpful to reset what the burden was at trial and what trial counsel was responding to.
You think that the three of us don't understand what the burden was at trial?
Very confident that the three of you understand what the burden was at trial, Your Honor. And what the state was doing was having Dr. Lavezzi present a very vivid and shocking picture to the jury of what happened to Faith. She said she was struck 13 times in the head as part of a single incident that occurred all on the evening of December 5th.
But on cross-examination, weren't they able to establish that, she's talking, over that it could be within a number of days, and weren't they able to make significant leeway in terms of diffusing that testimony?
So I don't believe that they were, Your Honor. On cross-examination of Dr. Lavezzi, she was never pressed on the question of whether or not there were 13 impacts, and the defense's witnesses never challenged whether or not there were 13 impacts. The jury was never told this child was not, in fact, hit in the head 13 times. That picture was not taken away from the jury. On the question of timing, Your Honor, we were able to elicit in the post-conviction proceeding an admission from Dr. Lavezzi that when she said at trial all of these injuries occurred around the same time, that in fact what she was talking about was a 3 to 4 day window. But at trial, her testimony was they all occurred at around the same time. The state emphasized in closing all of these injuries happened at the same time, and there wasn't any testimony that took it away from a vague statement that suggested it all happened as part of a single incident to getting actual clarification of what she meant. And there's a vast difference between a 3 to 4 day window in terms of when various injuries could take place and a single incident occurring around 9 o'clock in the evening on December 5th.
The state's theory then was it happened in one incident. The defense's theory was also that it happened in one incident from an accidental fall. And you have trial counsel who has over 30 years of experience in criminal defense. How is that not a strategy choice to go with a simple causation argument versus what you're now advocating of a highly technical battle of the experts?
So trial counsel went with a highly technical battle of the experts, but part of what is incumbent on trial counsel, and it's in the court's ineffective assistance jurisprudence, is to do a full and thorough investigation and understand what possible alternative arguments there are so that when you make a strategic decision, you make an informed strategic decision. And trial counsel here did not investigate whether there were alternative causes occurring outside of that narrow box that the state put the case in that could be offered as explanations for why this particular child had a fatal outcome from what might otherwise have appeared to be an innocuous injury. And so she didn't investigate and didn't attempt to determine whether or not there would have been a basis to say, could the child have had...
You called it an innocuous injury. There were bruises and contusions all over this child's body, were there not?
So there were bruises and contusions on the child, that's correct, and there was a host of explanations for why different of those bruises may or may not have occurred. And what I'm trying to illustrate is what trial counsel presented.
But you understand the difficulty in terms of a jury, that sees a picture and gets presented evidence of a child that appears to have had injuries all over its body, that becomes very problematical from a defense.
Absolutely, which is why it's all the more incumbent upon trial counsel to present the jury with an explanation that will help them understand what happened. And landing without...
Didn't they do that, though? I mean, that is exactly what they did. They had someone come in to present an alternative explanation of what happened, which appeared to be the strategic decision of the trial counsel. It's that she fell. I mean, that was the explanation.
Well, the problem with how they explained that to the jury at trial is that trial counsel presented a simulation for a single fall that she failed to lay any factual predicate for. She had an expert come in who said, I'm going to show the child falling out of a chair, and I'm going to show the child falling out of a chair from having reached for a piece of pizza. And the problem is trial counsel didn't lay any foundation to suggest that the child was ever on a chair, didn't lay any foundation to suggest that the child was there and reaching for a piece of pizza. And so the explanation that trial counsel gave to the jury was an explanation that had no factual support. And the state seized all over that in its closing argument and in its cross-examination of that.
But isn't that because even the defense's theory was the fall was unobserved? Nobody was around. The child was out of the room where I think it had ran from the bathtub. So how could they lay a factual predicate?
Well, so the defense's theory absolutely is that the fall was unobserved, but adding layers, designing a simulation that says, okay, we don't know exactly how it happened. We're not going to present you with a witness who will tell you how it happened, but I'm going to do a simulation that tells you that the child was definitely in a chair, was definitely reaching for a piece of pizza, and that's how the fall occurred, just puts it in direct conflict with defense's theory.
Let me ask this. Do you think that the 13 separate impacts was the critical piece of evidence in the case?
So I think 13 separate impacts was really the central pillar of the state's theory. To be able to say...
And in looking at the state's brief in this case, they don't even address that, do they?
So the state's brief doesn't specifically call out the number 13, but it does present the volume of injury to the child as part of its explanation for why the state believes that this was an obvious case. But the state at trial absolutely emphasized 13 impacts. It was featured In the closing, they told the jury at least 3 times during closing argument, this child was struck in the head 13 times, and that doesn't sound like it happened from a single fall. And trial counsel here, rather than contest 13 impacts, actually had her expert reaffirm that 13 impacts was not consistent with the defense's theory of the case. She asked her expert, there were 13 impacts, and that doesn't sound like it's consistent with a single fall. Her expert said, no, it doesn't, and then she just moved on. So the jury was never left with anything to explain what happened to the child's head other than she was struck 13 times.
All right, so, and your position would be that that in and of itself is sufficient for the granting of a new trial?
Do believe that in and of itself was sufficient for the granting of a new trial. Having the jury confronted with a medical story that says this child was struck 13 times, not hearing credible medical testimony to say that 13 times is just unsupported, and in fact, there's no more than 2 or at most 3 impacts that we see, and we know that at least one of those, based on the blood staining that was done during the autopsy, occurred several days prior to December 5th. Just that alone, not having that information, was prejudicial to the jury and could have influenced the outcome of the case.
But if the defense had engaged in the theory you're now espousing, wouldn't that have opened the door to another one of Miss Ray's child's testimony that he may have seen Miss Ray slamming the child's head into a sink?
So that door was wide open already, Your Honor. I mean, the theory of the case that the defense presented is this was an accidental fall, and there wasn't anybody around who witnessed what happened. If there's an eyewitness who witnessed what happened, the door's already been opened by the defense presenting that theory of the case, and suggesting an earlier injury may have contributed to the cause doesn't open the door any more than it already was.
But trial counsel in post-conviction said they made strategic decisions not to go certain angles just to avoid that testimony coming in. Doesn't sound like it was wide open, because I can't imagine more damning testimony in a case like this, but the state didn't present that in its case, did it?
The state didn't present that in its case because we were dealing with a witness that was not going to be competent to testify. They didn't hold it back because they didn't think that the testimony would be at issue or that they didn't think it would be beneficial. The testimony would already have squarely rebutted the defense that trial counsel chose to put on. If she did, in fact, make decisions not to present particular evidence because they were worried about that testimony coming in, that, I think, in itself is ineffective because you're worrying about something that you've already opened the door to. But, again, this testimony was not going to come in. The witness was not competent to testify, had been excluded from testifying at a prior proceeding on competency grounds.
Let's say that the defense is able to establish hypothetically that some of the injuries to the head had occurred in 3 to 4 days prior to that. That is, you're suggesting that leads to a different outcome of the trial, and why is that necessarily?
Well, so one of the key reasons that Violet Ray was the defendant here is that when the state put the case in the box, 13 impacts all at the same time, all on the evening of December 5th, Violet was the only one home. She was the only adult.
Miss Ray was the only one.
Miss Ray was the only one home. She was the only adult who was there with the child when the state says that the injuries occurred. If you expand it to a 3 to 4 day window, that goes away. There's a whole host of different individuals who have contact with and access to the child over the course of that period. And so the ability to say it must have been Miss Ray because she was the only adult there goes away for the state.
But it also seems at other points in your brief that you try to suggest that there were other medical causes for death rather than criminal conduct. I mean, is this just throw everything at the wall and see what sticks?
No, Your Honor, it's not throw everything at the wall and see what sticks, but it's dealing with a situation, as Your Honor alluded to earlier. This jury was confronted with a case where they had images of a 2-year-old that were difficult to see, a case that was narratively difficult to do, and looking for some explanation to help the jury understand what happened to the child. And those explanations include a host of non-criminal causes that explain the injuries.
So the defense hires 2 experts, in the case. And so the fact that there are other experts that might have been better than they, does that constitute ineffective assistance of counsel?
So we're not basing the argument on the notion that the experts that were presented at the post-conviction hearing may have been better than the ones at trial. Yes, no, but what the argument on the experts is that this is a case that called for experts with specific expertise. So the cause of death was particular complications resulting from brain injury. That's the kind of case that calls for a neuropathologist, for an expert in the brain who can understand and explain to the jury just how that complicated part of the body works. And they didn't have that expertise at trial.
I've seen these cases for 30 years, and it's not uncommon at all not to have an expert with that qualification in these cases.
And I think in this case, just because, I mean, in part, the medical examiner diagnosed specific internal brain injuries that she said were indicative of trauma. So, for example, the traumatic axonal injury. She reviewed a special slide. She said, I can see this traumatic axonal injury. That, in and of itself, demonstrates that this is an abusive trauma. And having an expert who can say, I know how to read these slides, I know how to interpret axonal injury, I'm able to respond to that, is essential in a case like this, and trial counsel didn't have it. Indeed, trial counsel didn't even get the evidence that the medical examiner relied upon to make that diagnosis, and so the defense's expert couldn't possibly respond to it at trial.
But that argument isn't all that persuasive to me, because I don't think that there was anything to contradict counsel's testimony that the expert didn't think that those slides were important, and said that to the lawyers. And it wasn't until the post-conviction hearing where he apparently has a change of mind. But I didn't see anything in the record where he disputed their testimony that he had told them this isn't important.
So there was correspondence between the expert and trial counsel in advance of trial where he says, if the diagnosis of traumatic axonal injury is important to the case, then I need to see the slides to be able to look at it. He put it to trial counsel to say, you tell me how the state's identification of this injury relates to the defense of the case, and it was trial counsel who decided it wasn't important, not the expert.
Is it your argument that, and I'm sorry, I know you're under your rebuttal, but is it your argument that if they had this neuropathologist that would testify the injuries were consistent with a fall from a chair, as the defense theory in the trial was, or that they would go in an entirely different direction of a theory of defense?
So the neuropathologist would have explained why the diagnoses that Dr. Lavezzi made during the medical examination of specific internal injuries associated with abuse were flawed diagnoses, and why the injuries that actually occurred in the brain were not consistent with abusive trauma, but were instead consistent with complications resulting from a lack of oxygen to the brain. It would have bolstered the idea and helped the jury understand why, for this particular child, a shortfall made her uniquely vulnerable to a fatal outcome. I'll reserve the rest of my time. Thank you.
May it please the court, counsel, good morning. Kelly Nealon on behalf of the state of Florida. As I've laid out in my brief, counsel had a strategy, counsel had a decent strategy. They haven't shown that counsel was ineffective with this strategy.
I'm not quite as flippant about that as you appear to be, but in your brief, I don't think that you really adequately addressed the issue of the 13 separate impacts, and that seems to me to be a very important issue in this case.
Well, we don't know that, they didn't show that there weren't 13 impacts.
No.
And no one has addressed the testimony of Dr. Schooler, who saw this child at the emergency room when she was airlifted to Shands Hospital. He's a neurosurgeon. He did the test to determine that this was not a non-accidental trauma. All of her workups came back normal. He said it was a traumatic brain injury that completely wiped out her brain. And no one has addressed that testimony. If they had called an expert, which none of their experts have also...
There is significant dispute as to whether there were the testimony of the medical examiner at trial really varied in some significant points with her testimony at the post-conviction relief hearing.
I don't
And-
believe it did.
She testified at trial that these 13 impacts occurred in a single time and commensurate with the injury and the death of the child, and then comes in at the post-conviction and says, well, by that, what I meant really was 3 or 4 days. You don't think that that's a significant fact?
There were bruises on the child's head. Even her father said she had fallen on the porch and hit her head. I mean, this was,
Now,
no, the cause.
We're talking specifically about the testimony that there were 13 impacts to this child's brain, and her testimony at trial that they all occurred at the same time, and then her testimony at the post-conviction relief hearing that by same time I meant 3 or 4 days. That's dramatically different testimony.
That does not change the fact that this child died of a traumatic brain injury that was inflicted on the night of December 5th.
Well, if it occurred over 4 days, that's not necessarily so.
Yes, it is, based on the testimony. She was taken to the hospital with a subarachnoid hemorrhage. Like I said, a traumatic brain injury, not something that happened over the course of 3 or 4 days.
If defense counsel chose to go with what I'll call a more simple causation explanation, that it was a fall from a chair from a short distance, does that relieve her duty or obligation to research and delve into the more technical and scientific explanations that defense counsel's now espousing?
Number one, counsel did. She testified at the hearing that she did delve into all these. She said she worked extensively with Dr. Woolley in this case. She read all the medical literature. She had 30 years of trial experience. So no, I don't think she flat out rejected that, but yes, she came up with a strategy that was consistent with the evidence. And we can't leave out all the other evidence that this child, according to the mother's statement, was found lying on the kitchen floor at 9 o'clock at night. Someone from the house called her parents, which wasn't her, which was probably the 5-year-old. Someone from that house, probably the 5-year-old, also called 911. 7.5 hours later, when the deputy showed up, and this was after they had already turned down one deputy's assistance to transport the child to the hospital. 7.5 hours later, when the police show up again, they finally transport this child to the hospital.
Oh, but this woman was convicted of first-degree murder, and you're putting that might be a great case for some sort of neglect or reckless disregard, but this is a first-degree murder conviction.
Based on aggravated child abuse. And you can't just look at the head injury, because even the medical examiner said, yes, this can happen in a fall. But you have to look at all the other circumstances, which none of their experts at the hearing, and they admittedly did not look at those. The one expert said, oh, well, yeah, there was evidence of corporal injury, but she didn't die from that, so that didn't factor into my analysis. And when a child has numerous deep bruises on their back, on their buttocks, on their thighs, and bruises behind their ears, one behind each ear, that certainly indicates evidence of child abuse, which the doctor at Shands Hospital, that's why he did all that workup. He said this is commonly seen in child abuse cases.
When Ms. Ray directed her counsel not to point the finger at her husband, is that binding on defense counsel, or should she have delved further into that?
No, I think I cited a case that when they're not ineffective for following their client's directions. I mean, you can even do that in a death penalty case. I mean, the client says don't put on any mitigating evidence. You don't put on any mitigating evidence. So.
Did you respond in your brief to the issue as to the ruptured bridging veins?
I'm sorry?
Did you respond in your brief to the claim as it related to ruptured bridging veins?
No, I did not respond to every single little medical thing that came up in the testimony.
Did you respond?
Because this is an overall.
Did you respond to the arguments vis-a-vis the stain slides?
Dr. Woolley said he doesn't normally use them. So
My question is, did you respond in any fashion in your brief to that?
I cited to the trial court's order. The trial court's, 40-page order denying relief and attached it to my brief. By the time I set out all the facts in this case, there was not a whole lot of space left for argument, and it's the trial court's order is presumed correct, so I just relied on the trial court order. And overall, looking at this, not as a retrial, but as an ineffective assistance of counsel claim. And would the outcome have been different? No. Are there any further questions? Then I would ask this court to affirm that extensive order of the trial court in all respects. Thank you.
So, Your Honors, what the jury heard from the state is that the child suffered 13 impacts, all as part of a single incident, and that there were specific injuries diagnosed in her brain that indicated that there was abuse. And what the jury heard from the defense counsel was she fell. What the jury didn't hear, but what the evidence supported, is that there were not, in fact, 13 impacts, that the fatal injury was not necessarily December 5th at 9 o'clock in the evening, that the brain injuries that the medical examiner relied upon to bolster the conclusion that this was abuse, not tiny little things like counsel wants to present now, but that there was axonal injury and that there was tearing of the bridging veins, either didn't happen or weren't indicative of abusive trauma.
How do you deal with the testimony from the emergency room physician?
So the testimony from the emergency room physician was the reaction in the moment. What the state relied on to actually demonstrate this is how the injuries happened, this is the proof that we have that there was abuse, was the medical examination performed by Dr. Lavezzi. Dr. Schooler's workup in and of itself would not have been sufficient to carry the day for the jury, but for the medical examiner's testimony and presentation of medical evidence.
It's consistent with that testimony. It's consistent with the medical examiner's findings, is it not?
So his initial observations are consistent with the medical examiner's findings. His analysis of it was not an autopsy-level analysis. It wasn't the kind of in-depth analysis that one would do if one was actually really trying to figure out what did in fact happen. It was something that he saw there was a potential indication of, we should look into this, and then it was the medical examiner ultimately who did the looking into it and who set out the bases for the conclusion, which is why it's so important to respond to what the medical examiner did. And the additional information that the jury never heard that was apparent in the record is that this child did present specific conditions that made her uniquely vulnerable. So there was identification of sickled blood cells in the slides that were done at autopsy. The expert and trial counsel expert flagged that for trial counsel at the time. Trial counsel admitted there was absolutely no strategic reason for not presenting evidence of sickled cells, and sickled cells explain a loss of oxygen and a loss of circulation to the brain, which explain the ultimate swelling and brain injuries that the child had.
But that would just supplement the defense theory at trial that it was a fall from a chair from some short distance, correct? That's not a whole new theory of defense.
It would give the jury something to grab onto to understand why, in this particular child, an accidental injury resulted in the fatal outcome that she had. All that trial counsel was able to present was she fell. She didn't give the jury anything to allow them to understand how that explained what happened.
Thank you, counsel. I believe your time is up.
Thank you.